legislatures. Rules for identifying criminals. Directions. A similar post on the same issue was made 2 days back, in fact, for prelims MHA notification of convicts biometrics. This is in continuation of that and will be the revision. Context. The Ministry of Home Affairs MHA notified the rules governing the Criminal Procedure Identification Act of 2022 and it was passed in Parliament also. What is the legislation about? Repeal the Identification of Prisoners Act, 1920 empowers magistrate. The act empowers a magistrate to direct any person to give measurements measurement collected in physical form or in a non-standard digital format. It shall be converted into standard digital format and thereafter uploaded to the database as per the SOP. Insights on India. Com 25. Authorized users. Only authorized users could upload the measurements to the central database in an encrypted format. Measurements include finger impressions, palm print and footprint photographs, iris and retina scan, physical and biological samples and their analysis including DNA profiling, behavioral attributes including signatures, handwriting, any other examination referred to in Section 53 or Section 53A of the Code of Criminal Procedure, 1973. Concerns about the Act. Issues of privacy. It allows the recording of samples of even political detainees. The rules do not mention the procedure to be adopted for convicted persons. Repository of the data. The National Crime Records Bureau NCRB, under MHA, will be the agency for storing and preserving the data of arrested persons. State government can store data, but it shall provide compatible application programming interfaces for sharing the measurements or record of measurements with the NCRB. Provisions for the destruction of records in case a suspect is acquitted, yet to be specified by the NCRB, nodal of FISA. Any request for the destruction of records shall be made to the nodal of FISA who is to be nominated by the respective state government. Recommendation for destruction. He will recommend the destruction after verifying that such a record of measurements is not linked with any other criminal cases. Insta links. The Criminal Procedure Identification Act, 2022. Mains links, Q. Discuss different types of cyber crimes and measures required to be taken to fight the menace. UPSC 2020. Judiciary. CJI of India, from Lodha to Ramana. Context. Over 75 years, the Indian Supreme Court has already had 49 Chief Justices. Justice Y.V. Chandrachud, in the 1980, had an exceptionally long tenure of over 7 years, while at the other extreme, Justice K.N. Singh occupied the office for a mere 17 days. Role of judiciary. Fundamental rights. Its primary responsibility is to ensure that the fundamental rights of citizens guaranteed under the Constitution are not diluted or eroded by the state. Judiciary manifests its superior nature through Kesavananda Bharati, 1973. The court assumed the power of judicial review over constitutional amendments. Judicial appointments. It assumed the power of judicial appointments to itself and the high courts. Article 21. It expanded the fundamental right to life and liberty under Article 21 of the Constitution. PIL. It ensures the right to approach courts through public interest litigation. Powers of CJI besides normal judicial duties. Appointment of judges, selecting judges for appointment to the higher judiciary, number and composition of benches, deciding the number and composition of benches adjudicate on different kinds of cases. 3 periods. From 1950 to 1971, the Chief Justice had complete authority over judicial appointments. The recommendation of the Chief Justice would always be followed, even to the extent of powers of a veto. Between 1971 and 1993, committed judges, the executive insisted on appointing committed judges to the Supreme Court. Prerogative, the executive exercising prerogative in appointing chief justices. The first judge's case 1981, the opinion of the CJI would not be binding on the government. Second judge's case 1993, judiciary practically wrested the power of appointments back from the executive. From 2014 to 2022, Justice Lodha, he revived the dormant trend of direct appointments from the bar to the bench in the Supreme Court. Justice H.L. did too. The fourth judge's case, concerning the validity of the National Judicial Appointments Commission (NJAC) Act. Justice T.S. Thakur, he set the National Judicial Data Grid rolling, which today connects all levels of the judicial system and provides a surfeit of information to litigants. Justice J.S. Khehar, landmark judgments, including the right to privacy in triple talaq judgments. Revived debates on the lack of transparency in 26 or Insights on India. Com. Fairness in managing the roster in the Supreme Court. Conviction and subsequent imprisonment of a High Court judge. Justice Deepak Misra, press conference, held by his 4 fellow judges, condemning the CJI's internal administrative decisions. Impeachment motion was proceeded against him. Constitutional benches, set up the maximum number of constitutional benches as CJI. Justice Ranjan Gogoi sat in the hearing of a sexual harassment complaint made by an employee of the Supreme Court against himself. Secrecy issues, Assam's National Register of Citizens (NRC) matter, the Rafale dispute, the electoral bonds issue, habeas corpus petitions wake of the abrogation of Article 370. Ayodhya dispute, Justice Sharade Bogde, preferential treatment to certain matters. For example, in the bail matters of journalists Siddiq Kappan vs. Arnab Goswami state the controversial farm laws. Ad hoc judges, issuing guidelines on the appointment of ad hoc judges to tackle judicial pendency standoff within the collegium over the appointment of a judge to SC. Justice N.V. Ramana, certain bail orders and stays e.g., Sedition Pegasus Inquiry, the decision on the Prevention of Money Laundering Act. Significantly large number of appointments in the higher judiciary, including appointing many women judges. No constitutional benches were formed. The future, Justice U. Lalit, taken initiatives in the formation of benches and certain initial orders that he has given, e.g., Kappan and Setalvad cases granting bail to individuals where the original indictment itself was without basis. Conclusion: a dynamic and thoughtful leadership, supported by queen judges, should be able to ensure that the challenges and responsibilities are met appropriately. True custodian, Supreme Court should live up to the hope of being the true custodian of the Constitution and protector of fundamental rights. Doctrine of basic structure. was propounded by the Indian judiciary on the 24th of April 1973 in the Keshavananda Bharti case to put a limitation on the amending powers of the parliament so that the basic structure of the basic law of the land cannot be amended in the exercise of its constituent power under the constitution. The decision constitutes a high watermark in the assertion of the court's judicial power in the teeth of a determined majoritarian regime. Much later, in 2007, a different bench of 9 judges in IR Coelho vs. State of Tamil Nadu, in a unanimous decision, authoritatively upheld the narrow majority view of 7:6 in Kesavananda Bharti and gave it permanent constitutional validity. Insta links, CJI. Mains links, Q. Critically examine the Supreme Court's judgment on the National Judicial Appointments Commission Act, 2014, with reference to the appointment of judges of higher judiciary in India. UPSC 2017. Q. Other than the fundamental rights, which of the following parts of the Constitution of India reflect the principles and provisions of the Universal Declaration of Human Rights 1918? UPSC 2021. Preamble 2. Directive Principles of State Policy 3. Fundamental Duties. Select the correct answer using the code given below. A and 2 only, B 2 only, C 1 and 3 only, D 1, 2 and 3 ans, D. Live streaming of SC hearing. Context. SC will live stream the constitutional bench hearing from September 27th, as a part of third phase of a court's project's use of information technology in judiciary. Why live stream? SC Swapnil Tripathi case, 2018 live telecast of court proceedings as part of the right to access justice under Article 21. SCSA Committee. It set up model rules for live streaming and recording of court proceedings in India. Other courts. 6 HCR already live streaming their proceedings on YouTube. Gujarat, Orissa, Karnataka, Jharkhand, Bihar, and Madhya Pradesh. What is Constitutional Bench? Or Insights on India. Com 27. Under Article 145(3), any case involving a substantial question of law as to the interpretation of the Constitution, must be decided by a bench of at least 5 judges. Such a bench is called a Constitution Bench. Benefits. Will ensure transparency and public scrutiny, will help in the decongestion of courts, improve physical access for litigants and the trust of people in the judiciary, help in legal research and training, encourage legal awareness limitations, limited access to digital infrastructures like computers and mobiles, lack of internet penetration in remote areas, prevalence of digital divides among rural, urban and men-women, lack of awareness among the public, lack of trust in ODR services, privacy and confidentiality concerns. Supreme Court has approved a set of guidelines and it has the power to withhold broadcasting in sensitive matters, e.g. matrimonial disputes, matters involving juveniles, national security, rape cases etc. International examples. Courts in the US allow for audio recordings and transcripts of oral arguments. In the UK, recording of proceedings of SC is allowed. Instalinks virtual courts and the way forward. Mains links. Q. The idea of the A-court system can provide the judiciary with an opportunity to address the problem of delayed justice. Discuss. 250 words. Q. Which one of the following in Indian polity is an essential feature that indicates that it is federal in character? A. The independence of the judiciary is safeguarded. B. The union legislature has elected representatives from constituent units. C. The union cabinet can have elected representatives from regional parties. D. The fundamental rights are enforceable by courts of law. Answer A. Issues faced by women in judiciary. Context: issue of prevailing patriarchy in the judiciary case. In a recent incident where a sessions court in Kerala granted anticipatory bail to an author and social activist in the state in a case of alleged sexual harassment, observed that the offense under Section 354A of the Indian Penal Code, assault or criminal force to a woman with intent to outrage her modesty, is not prima facie attracted when the de facto complainant was dressed in sexually provocative dresses. This raised the issue of prevailing patriarchy and the struggle women have to face in our system. Issues faced by women in judiciary. Lack of support. Women employees in the criminal justice system, whether it be police, court, or prison, often face discrimination, lack of gendered workspace, and derogatory comments. Low representation in judiciary. Justice Indira Banerjee, the senior most woman judge in the Supreme Court, highlighted that the top court since its inception in 1950 has seen only 11 women judges. Prevalence of anarchic laws and customs. In Bradwell vs. the State of Illinois 1872, the Supreme Court of the United States held that God designed the sexes to occupy different spheres of action and that it belonged to men to make, apply, and execute laws, and regarded it as an axiomatic truth. Need for sensitization, raising awareness. Inclusion of feminist jurisprudence in the curriculum for law students and sensitization of legal practitioners and judicial officers about feminist jurisprudence. Respecting individual choice. In a liberal democratic state, choice of dress as a self regarding act, over which the individual is sovereign, as J.S. Mill pointed out. Insta links. Women in judiciary. Mains links link it with the issue of lower representation in the judiciary. This question was directly asked in 2021 mains. Q. Discuss the desirability of greater representation to women in the higher judiciary to ensure diversity, equity, and inclusiveness. 250 words. Only 16% of human trafficking cases in 2021 saw convictions. Context: the conviction rate in human trafficking cases across the country continues to be low, according to the latest report of the National Crime Records Bureau (NCRB). Key highlights: only 16% saw convictions against cases registered under the Anti-Human Trafficking Units (AHTUS). Data not available. The data on convictions was not available for 11 states, and as many as 8 states and 3 union territories saw no convictions at all. Top performer. The top performer was Jharkhand, which saw convictions in 84.2%, 84.2 of the 92 cases that were registered in 2021. 28 O. Insights on India. Com. Zero conviction. 11 states and union territories reported zero convictions in 2021. Highest trafficking cases. The highest number of trafficking cases was registered in Telangana, 347 cases, Maharashtra, 320 cases, and Assam, 203 cases. General deep in cases. Barring Telangana, all states saw a dip in cases in 2020, the first year of the pandemic which saw lockdowns. Previous years, in 2020, only 10.6% of the total cases saw convictions, and in 2019 there were convictions in 22%. Human trafficking. It is a form of modern day slavery involving the illegal transport of individuals by force or deception for the purpose of labor, sexual exploitation, or activities in which others benefit financially. Constitutional or legislative provisions related to trafficking in India. Article 23, Traf. Trafficking in human beings or persons is prohibited under the Constitution of India under Article 23, 1. The Immoral Traf. FIC Prevention Act, 1956 ITPA. It is the premier legislation for the prevention of trafficking for commercial sexual exploitation. Section 370 and 370A of IPC, it provides for comprehensive measures to counter the menace of human trafficking, including the trafficking of children for exploitation in any form, including physical exploitation or any form of sexual exploitation, slavery, servitude, or the forced removal of organs. Interlinks. Human trafficking, NCRB. Mains link, Q. Though the Human Rights Commission have contributed immensely to the protection of human rights in India, yet they have failed to assert themselves against the mighty and powerful. Analyzing their structural and practical limitations, suggest remedial measures. UPSC 2021. Statutory, regulatory and various quasi-judicial bodies. Should the AC insist on elections? The legal ground on which elections can be mandated within political parties. Article 324 of the Constitution, or Section 29A, of the RPA 1951, Court said that the AC can actually regulate internal structures, organizations or elections of the party. Constitution of Party. The AC expects political parties to abide by their constitution, a copy of which is submitted to the Commission when the parties are registered. No interference. Commission cannot step in or criticize if anyone is elected unopposed. Importance of internal elections. Contest of ideas. Internal elections lead to meetings and contests of ideas. For example, in US elections, the selection of the candidate to be the presidential nominee is done via debate. Upward mobility. Internal elections are key for upward mobility. What will state funding of political parties do? Money from corporates. Stop parties from taking money from the corporates. No of votes. Political parties will receive money as per the number of votes polled. Law Commission Report 1999 strongly recommended that there should be a mechanism for it. Should there be new laws making organizational elections mandatory? New interpretations. There is a need for a new interpretation and some bold moves from the AC re-interpreting the existing laws, like, political parties should hold organizational elections regularly. The parties are required to inform the AC about changes in their office bearers and addresses. They are required to submit a document of expenditure incurred during elections and in the non-election period. Interlinks. Political parties in India. Registered and recognized political parties are UPPS. Mains links, Q. On what grounds a people's representative can be disqualified under the Representation of People Act 1951. Also, mention the remedies available to such a person against his disqualification. UPSC 2019. Ed. More teeth and bigger muscles. Context. Since 2014, the Directorate of Enforcement (ED) has investigated 121 prominent politicians and has arrested, questioned, raided, or filed FIRs against 115 major opposition leaders. Analysis of powers with ED. Power contrary to CBI, unlike agencies, particularly the CBI, the PMLA allows the ED to take cognizance of any offense with or without the consent of state governments. Powers contrary to NIA. The types of offenses that NIA can investigate are limited to about a dozen offenses compared to ED, which enjoys a wide-ranging schedule across the country. Insights on India. Com 29. Wider extent, the ED's ambit extends from serious crimes such as terrorism to the hunting of wild animals, and from the infringement of copyright to false trademarks. Other powers under PMLA. It gives investigators the power to arrest and attach properties and assets of accused, impose stringent bail conditions, make a statement recorded before an investigating officer admissible in court as evidence. Powers through various amendments. Criminal conspiracy. Under Section 120B of IPC, it was added to the PMLA's schedule among various other offenses. International jurisdiction. For tracking laundered money amendments in 2015 and 2018, the ED was allowed to attach properties in India equivalent to properties acquired abroad through laundered money. Explanations inserted into the PMLA in 2019. The government allowed the ED to attach properties earned directly or indirectly through alleged criminal activity. Issues with the PMLA. Statement admissible. It is the only act in the country in which a statement recorded before an investigating officer is admissible in court as evidence. Strict bail conditions. SC upheld the validity of all the provisions of the PMLA, including strict bail conditions in money laundering cases. Interlinks. PMLA. Ed. Mains links. Q. India's proximity to two of the world's biggest illicit opium growing states has enhanced her internal security concerns. Explain the linkages between drug trafficking and other illicit activities such as gun running, money laundering, and human trafficking. What countermeasures should be taken to prevent the same? UPSC 2018. CBI. Freeing the caged parrot. Context. Despite several observations made by the Supreme Court against the efficient functioning of the CBI, nothing has happened to improve the situation. Supreme Court cases on CBI. Jan Hawala Case 2014, Criminal Negligence of the CBI in Militancy and Corruption Related Matter. Vineet Narain. Judgment 1997, the CVC be given statutory status and be entrusted with the responsibility to supervise the work of the CBI, ensuring its efficiency and impartiality. Recommendations for improving the functioning of CBI and CVC. Amendment. The CVC Act should be amended, providing for a 5-7-member CVC, which could broadly assume the role visualized for the Lokpal. Prevent favoritism in selection. The selection process to be more broad-based to prevent favoritism or from controversial persons being appointed. CVC should constitute an advisory committee. consisting of at least 11 members drawn from criminologists and forensic science experts. This will augment the professional input in its functioning. Expert or professional assistance. CVC should be given the power to go to any expert or professional to assist it in screening complaints. No permission from the government. After assessing a complaint by broad-based CVC, there should be no need to seek prior permission from the government. CBI should be made functionally and financially independent of the controls of any government ministry department. The professional supervision over the investigations of the CBI should rest only with the CVC. Manner of the appointment of the CBI director. It should be broad-based as in the case of the CVC members. The other inductions, appointments in the CBI should be brought under the overarching supervision of the CVC. Better synergy between anti-corruption laws and grievance handling. The laws relating to whistleblowers and grievance redressal should be placed within the jurisdiction of the CVC. Conclusion. Responsible governance. Effective administration of anti-corruption laws at the grassroots is the key to responsible governance. Government interference. The state and their anti-corruption agencies would, therefore, need to be equally insulated from the state government's interference on similar lines. Not used as instruments of blackmail and intimidation. Rather, they should work with complete objectivity and in the interest of the nation. Insta-links, CBI, CVC. Mains links, Q. The jurisdiction of the Central Bureau of Investigation (CBI) regarding lodging and for and conducting a probe within a particular state is being questioned by various states. However, the power of states to withhold consent to the CBI is not absolute. Explain with special reference to the federal character of India. UPSC 2021. Prelims links, CBI, CVC, SC30O. Insights on India. Com. Q. With reference to Central Vigilance Commission, consider the following statements. 1. It is neither statutory nor an executive body. Though a Central Vigilance Commissioner is appointed by the President on the recommendations of a committee consisting of the Prime Minister, Union Home Minister and Leader of the Opposition in Lok Sabha. Which of the statements given above are correct? A. 1 only, B. 2 only, C. Both 1 and 2, D. Neither 1 nor 2 ones, B.